Welcome to Free Speech Unmuted, a podcast from the Hoover Institution. I'm here with my co-host Jane Bambauer from the University of Florida. I'm Eugene Volokh. I'm a senior fellow here at Hoover and also an emeritus law professor at UCLA. And we're delighted to have with us Ash Bhagwat, who is a professor at UC Davis Law School. And he actually knows a lot about the FCC and federal communications law. And it's always important, but especially in light of the events of the past week. So for those who have been, on vacation to Mars, perhaps, the FCC chair made a statement last week, which was understood, I think, correctly understood as essentially threatening some possible retaliation against ABC based on a particular statement that Jimmy Kimmel made on his show that seemed to blame conservatives for the shooting of Charlie Kirk, suggesting that the shooter was in fact a member of the MAGA movement, which apparently he was not. So the chairman basically called on ABC to suspend Jimmy Kimmel and basically threatened it with possible FCC retaliation. So Ash, tell us, what was he possibly threatening ABC with? Could he have made it stick? What should we think about that kind of threat? What's the legal significance or the legal implications of that kind of threat?
So lots of things to say. One, very obviously, the FCC has no direct power over ABC or Disney. The FCC regulates its licensees, which are the local broadcast affiliates of ABC that transmit ABC programming, but that is not ABC, the parent company. So what he was pretty explicitly doing was threatening those local licenses. And it turns out there are two companies, Sinclair Broadcasting and Nexstar, that own a whole bunch of ABC affiliates, and I'll come back to those companies in a sec. But that's where really the threat was going to, despite the fact that he said ABC. What was the threat? Well, he talked about the public interest. And what is true is that the FCC, the statute governing all of this, the Federal Communications Act of 1934, does say that the FCC should regulate broadcasting consistent with the public interest, convenience, and necessity. And there is this general idea that licensees are supposed to act in the public interest when using their license, because the license is seen as a privilege rather than some sort of a right, and it's something that's renewable. You don't keep your license forever. I think it's now 8 years. It used to be 5 years. So you have to go back and get it renewed. Is it possible that actually he could have taken legal action that stuck against licensees under the public interest standard? I think the answer is quite clearly no. It's the Communications Act is clear, and a million other things are clear, that the kind of viewpoint-based control of programming that the chairman was trying to sort of accomplish through the public interest standard, today, I don't think there's any legal grounds whatsoever for that. There was a time from the 1940s until 1987 when the FCC enforced something called the Fairness Doctrine, which was a set of rules that required more balanced coverage by broadcast licensees. And maybe one could get some hay out of that, but the Reagan administration FCC repealed that rule in 1987, despite the fact that the Supreme Court had earlier upheld it in the 60s in a case called Red Lion. Given the demise of the Fairness Doctrine, which honestly no one regrets, or almost no one regrets the loss of, I don't think there's any real legal threat that could stick. But here's where things get complicated, imagine if the FCC held up renewal of licenses for some of these local stations. That's life or death, right? And the reality is that in a heavily regulated environment, those kinds of slowdown actions can have significant economic consequences. And so people often cave in situations where if they would litigate, they would win, simply because they don't want to bear the risk or the delay or all of those other things. Finally, another complication is that the FCC has pretty broad regulatory authority over basically corporations that own law broadcast licenses, and mergers in this space are subject to FCC review in addition to regular antitrust review. And we all know that merger review can be extraordinarily risky because delays in merger approvals can be fatal to a corporate transaction if they go on for long enough. Even if you want to litigate, by the time you get all the litigation done, that the economic circumstances that supported the merger might all be gone. And in fact, Nexstar, one of these companies that is one of the largest owners of ABC affiliates, has a merger proposal pending before the FCC. And I guess what this tells me is something I have believed for a long time, which is that creating heavy government regulation in media spaces is honestly a terrible idea. The fairness doctrine was a terrible idea. It has been abused, it was abused when it was around. And all of this other stuff provides levers of pressure. And I'm not saying that they were used. Like I'm not aware of Chairman Carr saying anything about this merger. But corporate leadership, of course, knows all of this is out there and all of these risks are there. And so to what extent, on the other hand, it is also true that Sinclair and Nexstar generally are considered to be conservative-oriented corporations. So their actions in choosing not to carry Jimmy Kimmel, may have been voluntary. It's possible. It's not inconsistent with their general ideological take. Or maybe they saw it as political pressure. Frankly, if Brendan Carr had not spoken up, and his speaking up was incredibly foolish, in my opinion, then we would have known what these people genuinely wanted to do. But because he was issuing these threats, we can't know whether or not their actions were a result of this threat or not, because it is their decision, Nexstar's and Sinclair's decision not to carry Kimmel, that seems to have triggered ABC's decision to drop Kimmel.
Very helpful. Thanks very much. So yes, the government has more authority to regulate broadcasters and broadcast programming than it does over newspapers, let's say, which it has very, very little over the internet, rightly or wrongly. I think we probably mostly agree. Wrongly, the court has allowed such authority, but it has. Mm-hmm. Nonetheless, the authority is not nearly unlimited. In fact, it is quite limited if it actually comes to court. It's just that the government can make it very painful for people, even if they were eventually to win in court, and that's often a reason they don't want to litigate at all. So this actually brings up, of all things, the National Rifle Association. There was a case called NRA v. Vulo last year, where the court considered whether it's constitutional for, let me start again. I want to get the procedural posture right. There was a case last year, NRA v. Vulo, which actually bears on this question of government threatening, or in that case, allegedly threatening intermediaries with retaliation if they don't block something for a speaker. In that case, it was New York regulatory officials that were accused of pressuring insurance companies, financial intermediaries, to cut off or to limit their relations with the National Rifle Association because the allegation went because of the New York officials' disapproval of the NRA's viewpoint. NRA sued, and the question before the court was, if the facts were as NRA alleged, would that show a First Amendment violation? And the court said yes. It didn't resolve the facts, but it said if indeed the New York regulators pressured insurance companies this way, that would be an indirect attempt to interfere with the NRA's speech, but still an unconstitutional attempt. So I think the logic of that would very much apply if indeed the ABC was pressured into the suspension. Now we know it's just a temporary suspension, but pressured into it by the threat of FCC retaliation. Of course, the fact that there could, in theory, be a First Amendment claim doesn't mean that one will be brought and that it will be successful, given all of the procedural complications that are raised, questions like standing and the like. Among other things, I'm pretty sure that Jimmy Kimmel, for good business reasons, wouldn't want to sue the the government in a situation where it may reflect badly on his employer, or even if he leaves on his ex-employer. That's just not good business in Hollywood to publicize things like that through the legal process. But in any event, this could indeed, I think, given all that, be a First Amendment violation, whether or not it would come to court.
So yeah, can I ask something about the standing issue? Because the other case besides the NRA versus Vullo case that this incident is reminiscent of is the Murthy versus Missouri case. So that was the case that involved the Biden administration putting pressure on the social media platforms to remove misinformation, or at least what the Biden administration considered to be misinformation. And that case, the Fifth Circuit had found that there was something close enough to coercion. We had an episode on this, but the Fifth Circuit test didn't require strict coercion. But in any case, they found enough to say that there was a First Amendment violation. The Supreme Court dumped it on standing. And, since that case, the popular understanding, like when I hear people reference the whole, sort of Biden era scandal, they treat that case as a win for the platforms and suggest that, the government basically did nothing wrong. Here, I think these facts, Jimmy Kimmel, if he did decide to sue, which might not be smart, but if he did, he probably has the clean, or at least much cleaner version of, causation that was lacking in the Murthy case, because we have ABC hastily suspending him, and then a few days later, after there was counter pressure, reinstating him, which I think suggests that ABC really was chilled and then kind of embarrassed and had to sort of backtrack. And so, Ash, I'm wondering, given, I don't know, do you see uncertainty with something like standing, or do you see parallels between this and the Murthy case?
There are clearly parallels, and I think you're right, but I want to give one caution, which is it's why I earlier mentioned the fact that Nexstar and Sinclair both historically have conservative leanings. It's not inconceivable that just as in the Murthy case, people concluded that the platforms were going to do what they were going to do regardless of the Biden administration's pressure. It's not inconceivable that the argument would be made that actually Nexstar and Sinclair were reacting to their own preferences and that what Brendan Carr said was completely irrelevant. Do I think that's the case? No, I don't. But proof is always difficult, right? And if in fact Nexstar and Sinclair decided to cooperate with the FCC and testify that they would have done the same thing anyway, as the platforms did in the Murthy litigation, I don't know how you get past that.
Yeah, I think that's right. Now, Kimmel has an advantage that the plaintiffs in Murthy didn't have, which is presumably he's got buddies at ABC who would be willing to kind of tell him back channel, yes, we did this because of FCC pressure and there's evidence, and we won't just
indirect, but
turn it over voluntarily, but if you subpoena us, we'll provide it. Or they'll tell him, look, Jimmy, it wasn't about the FCC. It was about a lot of outrage from our business partners, and frankly, maybe you're not getting the audience that we'd like you to get. So he may have access to that information, but there also, I take it, there might be. I haven't fully looked into this, but there might be various immunities involved. It's hard to sue the government. It's hard to sue, in particular, an agency head for a statement that he made, which wasn't actually an official government action, just because presumably he'd have to do it together with other commissioners. So in any event, so there would be complications. But if we just step back and forget about standing and such, I do think it's important to recognize that under standard First Amendment law, government officials threatening intermediaries with a retaliation if they don't cut off certain speech, and if the speech is constitutionally protected, that is itself a First Amendment violation. Maybe nobody can sue over it, but it's something that I think we should pay attention to. And I think it's noteworthy that Ted Cruz, very conservative Texas senator, spoke out with regard to this and pointed out that this was a very dangerous thing for.
Yeah, as has Tucker Carlson, in fact.
I'm sorry?
As has Tucker Carlson.
I did not know that.
The FCC's move, yeah.
And so has Ben Shapiro. So to round out
good.
Because, as all of them point out, it's a loaded weapon, right? I mean, because the FCC will have a Democratic majority at some point, and then and they don't want to face that situation, especially because there's been muttering, incomprehensible in my view, but there's been muttering from this FCC under Brendan Carr that they want to revive the fairness doctrine, which I think in the internet era is completely crazy, and I would hope the Supreme Court would strike it down 9-0, because the scarcity conditions that justified the doctrine in the 60s obviously do not exist anymore. But that's, I think, but here's the thing that I find difficult to understand is that Brendan Carr knows all of this. This is not, in my opinion, a close First Amendment issue. Can the government threaten private parties in order to shut down speech? I mean, no. So what the goal here was is difficult for me to actually fully understand.
Especially given that, before Brendan Carr made those statements, Charlie Kirk was the victim, the martyr of circumstance. And then those statements completely turned the narrative around for at least the, moderate middle. Oh, right. So among the moderates, I'd say, or in any case, there's at least a competing news issue, right? Thanks to Carr. Yeah.
Right. So I'm not a political analyst of any accomplishment or predictive power, but my sense is what happened in 2024, among other things, is that the Democrats had badly overplayed their hands. They were running against a highly flawed, vulnerable candidate in Donald Trump. But in addition to their disinformation campaign of some people trying to pretend that President Biden was still up to things, and that badly backfired on them. In addition to that, I think they had taken some very aggressive culture war stances with regard to a variety of things, including just generally cancel culture, attempts at suppressing people's speech, as well as particular positions with regard to transgender issues that I think were way out ahead of, or at least different from what a majority of voters believed in many ways. And they were punished. It was a close election, and I think it's not unlikely that those kinds of issues did swing the couple of percent of voters, probably 1% if they had swung from one way to another. I'd calculated then the president now would be Kamala Harris, would have been. So likewise, it seems to me that the Republicans are in danger of overplaying their hands by portraying themselves as kind of out of touch with, I think, many American sentiments that this is the government going too far. But who knows? Who knows? Again, I can't even say with confidence why it happened in 2024. It's going to happen in 2028 or 2026. Who knows? So I wanted to, since you're here, I wanted to talk a little bit more about fairness doctrine and federal communications policy and such. I am not at all a fan of the fairness doctrine, and I'm not a fan of just generally lower protection for broadcasting. But I wanted to perhaps try to give the best version of the argument for some degree of extra broadcast control, just so we can lay it out for our audience. Can we shift to that? Or Jane, do you have more to say about the Kimmel matter?
No, let's shift.
So here is one way of reading the Red Line opinion. Red Line was the case that upheld both the fairness doctrine and the personal attack rule, which I think was in many ways different and more manageable than the fairness doctrine.
Can you describe both? I think yes, it might be useful. Yeah. Right.
So actually, Ash, why don't you tell us about the fairness doctrine and personal attack rule? Because I think I've got them right, but I know you have them right.
So they were always linked because they were both part of the same general philosophy that because a broadcast license is a privilege held on behalf of the public, what really matters is ensuring that licensees show the public the world as it really is rather than their own biases. So the fairness doctrine was a general requirement that A, they devote time to public affairs in their programming. They cannot just do sports and quiz shows. And B, that in doing so, they have a balanced sort of coverage. They can't just take a hard political slant, right? The kinds of things that today on cable news happens all the time, CNN, Fox News, you couldn't do that. The personal attack rule was connected and basically said that if you broadcast information that was attacking, I think it's a political candidate or an office holder, they had to be given time on air to respond. And the Red Line case actually involved a personal attack issue. But the reasoning of that case was that this is a reasonable thing to do because the number of licensees in any area is limited. Because remember, this is still the era when broadcasting means bunny ears and TVs, and there are only a handful of VHF stations and a few UHF stations that just did reruns. So you're really talking about very limited channel capacity. Though not that limited, honestly. And in radio, it was never that limited. But the logic was because of these limits, spectrum scarcity is the term that's often used, it was okay for the government to treat broadcast fundamentally differently from all other media, such as, at the time, print newspapers and magazines, later on cable television, later on the internet. Broadcast has always been kind of the odd duck, the one that's subject to more government oversight.
Got it. So thank you for laying it out. And so here is my one reading of the Red Line decision that strikes me as worth airing, because I think it's sort of the most sympathetic argument. So one way of thinking about it is setting aside for now scarcity as such, as opposed to well, in any case, setting aside scarcity as such. There are two kinds of broadcast regulations, not one, that were at issue in Red Line. The one that nobody talked about is the one that applies to 99.999% of us. And that's, we're not allowed to broadcast. If we try to broadcast, it's illegal. I think it's a crime.
Yes.
But because,
that's what Pump Up the Volume was about.
Exactly right. Well, blast from our childhoods or maybe teenage hoods. So it was illegal because we didn't have a license, and it's not like a driver's license. Oh, we just need to pass some tests. We couldn't get a license, and then 0.001%. It's such a much more privileged status than the rest of us did. They could broadcast. On this channel, and just because they had this special access, part of the deal was in exchange they have to provide some extra, some minor ability to participate for the rest of us, for the 99.999%. They had to provide some degree of balance, not all the time, just occasionally might have to air other views, or even kind of in the broadest version, some portion of the time, but nowhere near the majority that have to air balanced views. Likewise with the personal attack rule, if they're attacking you, and you're not allowed to, by law, you can't respond. You can't put up your own broadcasting equipment to respond. They just have to give you access. So that's the theory. The deal was, if you get the special privilege that the rest of us do not, whether or not there's that much scarcity or not, there may be more broadcast stations in your market than newspapers, but at least newspapers aren't operating the special privilege. You are. You're being given this special privilege, and there's a condition to provide some degree of access to the rest of the public. So that, I think, is perhaps the most sympathetic argument in favor of some version of those doctrines. Ash, what's your response to that?
First of all, yes, that is clearly the most sympathetic version of Red Line, with the idea being simply that because of those circumstances, and I think you can't get rid of scarcity, it's precisely because there's a significant limit in the number of broadcast frequencies that we can't all get access to broadcasting, right? In a way that even started to change once cable came along, because then you had public access and things like that. But so yeah, that is absolutely the most sympathetic argument in favor of both the personal attack rule and the fairness doctrine. The flip side argument, which the FCC actually itself made in 1987 when it repealed the fairness doctrine, was that this systematically disincentivizes hard-hitting coverage of public affairs. What it encourages is either avoiding public affairs or being so mushily centrist that no one's going to be offended. And that you're balancing those two policy considerations, right? I think that it was a mistake. I think that, in fact, the impact of the fairness doctrine was to create a mushy middle for most broadcasting. It's not a coincidence that Rush Limbaugh went in the air about a year after the fairness doctrine was repealed. Before that, he couldn't have, right? And not saying I'm a big fan of Rush Limbaugh, but that's the beginning of very politicized radio. So yeah, it's a policy choice. I think in 1969 it was a difficult policy choice. I think in 2025 it's absolutely not, because you can respond now, right? I mean, most people, and especially most young people, are not getting their news from broadcast television.
Yeah. So can I ask a question about that? Why is it that these broadcasting licenses are so valuable? Can you tell us a little about the economics of, it must be that more people still get their content from broadcast than I can imagine, given that you could access ABC shows over the internet and whatnot. So do you have a sense of why, why ABC would be afraid of Sinclair's power, for example?
Well, ABC is afraid of Sinclair's power because the way they reach cable audiences is via the Sinclair stations.
Oh,
right?
It's cable audiences.
Even if I'm getting my TV via Comcast, or even as I do via YouTube TV, if I want to watch Jimmy Kimmel, like the actual show, and I'm an old man, so I might want to do that, unlike the kids, I would go to the ABC channel that is the local broadcaster that is carried by both my streaming service or my cable service. So that's why ABC cares. Why?
So not enough people do over-the-top TV, to use that. Not enough.
Top.
Yeah, because you could also just go to the ABC app, and then Sinclair is not involved. Is that right? Maybe I'm not understanding
that. I am not sure. That's
okay.
Probably right, but I'm not sure whether ABC actually live broadcasted shows on its app, because that would be competing with its own licensees.
Yes,
and that would be
they probably don't allow it. Okay, got it.
The only TV I watch live is, frankly, NFL football, and I know there are a billion rules on co-broadcasting NFL football.
Got it. Okay.
Almost nobody gets their TV via bunny ears anymore. And so I, for years, have wondered why people are still maintaining these licenses and these broadcast facilities when it's a trivial amount of the viewing population, right? I don't know this for a fact, but what I can make out, and I'm a wireline telecom guy, not a broadcasting guy. I want to emphasize that in my background. But what I can make out is that if you're an existing broadcaster, you get access to other frequency, but that was theoretically once going to be used for high definition broadcasting. Dumbest idea ever in the internet era, but there you are. And there are perks that go with that actually have potentially very high cash value. That's the best I can tell, because the numbers do not show a lot of people relying on bunny ears, right? And the people who rely on bunny ears are, I'm sorry, but they're overwhelmingly going to be people that are the least valuable in terms of spending capacity, because they're doing it because they can't afford cable, and so advertising to them is not all that valuable.
You do realize that I don't know what fraction of our audience, but certainly well into the double digits, if not the majority, have never seen bunny ears. You want to tell them about bunny ears?
Sure, because I have to explain this to my students every year, right? Because again, when I start teaching telecom cases, they look at me like I'm a Martian. So back in the day,
Martians, I'm told, have
they have two.
Jokes.
2 years. Yeah. So back in the day, before cable television, which was, basically for most households through the 80s, cable television really was picked up in the late 80s, early 90s as a major technology. The only way you could get television is the same way you get radio in your car, which is via the electromagnetic spectrum. And then your TV, which was a huge thing that had terrible just visuals, but it had these two pieces of metal that stick out in a V on top of it, and those caught the electromagnetic transmission, which then converts using technology into a picture. Just as today, if you're listening to the radio in your car, like real radio, not internet radio, but like the local radio station, there's a antenna built into your car somewhere. It's now
we call that a unicorn horn. though, because it's only one, so we call it a unicorn horn instead of
right. And they're very inobtrusive now. Back in the day, the antenna on the car was also a big stick that you could see.
Yeah, but and you have
people
to
would
take it off
decorate
when
with
you
little...
go through go through
a car wash.
car
You
wash.
had to shove it down.
And some people decorated them with the little balls, remember?
Yes.
By the way, there is breaking news. Thank you, Scott. That breaking news for us at the time of recording that Sinclair has indeed announced that it will be preempting ABC's broadcast of Jimmy Kimmel and will be replacing it with news programming. So,
and this
there
is
you go.
it owns 31 ABC affiliates, so it's a considerable number. Although my guess is it's a relatively small fraction of the total ABC affiliates.
Small fraction of the total, yeah. And I think Nexstar may own more, but again, nothing near between them. It's still nothing near a majority of the total. But that is interesting because that cuts in towards the idea that maybe this really is their own voluntary choices.
Right. So Asha, let's return to this to what we were observing with regard to what Chairman Carr was at least trying to do, whether he succeeded or not, whether he was the but-for cause of the suspension or not. It sounds like he was trying to pressure ABC directly or otherwise into suspending Kimmel. And the question, and I think you're quite right, that this is potentially very dangerous, but the question is, what is to be done about that? Given that the FCC does seem to have this power, even if it's not going to bring back the fairness doctrine, and even if it isn't going to just cancel licenses, it does have power over these business deals of the affiliates. It has all sorts of pressure it can exert. What can be done? What can be done?
I mean, this is coming from me. This is going to sound crazy, but I have always favored a suggestion of how to do all of this that was promoted by Ronald Coase, the Nobel Prize-winning economist from the University of Chicago, which was, he said, just get rid of all of this licensing stuff and just sell property rights, tradable, sellable property rights to the airwaves, as we do in other contexts, in other forms of use of the electromagnetic spectrum, and get out of the censorship business altogether. I still think that's the better solution. I'm full libertarian on you, because I think that, especially in an age in which broadcast television isn't that important, the arguments in favor of close oversight have really gone away. Mm-hmm. And we're seeing why close oversight of conglomerates is problematic, especially because these companies are so big, right? It's not ABC. We keep saying it's ABC, it's Disney, right? And Disney owns so many different things that are subject to political pressure, many of them having nothing to do with broadcasting, that the number of places in which you have press points is just very high.
Right. And although that suggests that maybe cutting out FCC control is going to diminish them a little, but there'll be still mergers that they want to engage in, even outside of FCC jurisdiction. In principle, even if it's just a broadcaster, the mayor can call up the broadcaster and say, we're sending in some inspectors to inspect things. I'll bet you we're going to find wiring problems, right?
This problem has always existed, right? I mean, and there's nothing we can do about it. I think the FCC is particularly concerning just because it is full on focused on media and content all the time. The FTC's interests are much more broadly spread, but it's the risk of intimidation of media is hardly a new thing, right? It's been going on for a long time. Going back to the framing in many ways. And think about the Sedition Act, right? I mean, it's not
right. Although that was sort of a traditional intimidation. It was the threat of criminal punishment. There was a standard process for fighting it. The indirect ones are in some respects harder to deal with than the direct ones.
And again,
there's an argument that when the FTC makes some raises an eyebrow about antitrust or issues or something that can be have a bigger impact without as much public accountability. Mm-hmm. Certainly not as much outrage, right? From people who lose their content.
Of that. So the FTC recently approved a merger between two very large advertising agencies. And one of the conditions was that advertising agencies not deny platforms advertising based on the content they carry. This is all on behalf of Twitter X and the litigation going on. Twitter basically sued a group of advertisers claiming that they were being boycotted. And And
Wow.
one of my colleagues and I filed comments in the FTC proceedings saying this is really problematic. Like they're using antitrust law as a lever to get at content. So this is happening, right? This is not, but the FCC has jurisdiction focused on the broadcasting industry. So I'm not suggesting if we got rid of the FTC tomorrow and took on the Ronald Coase approach, would that solve all the problems? Absolutely not. Absolutely not. And as media ownership has become part of large corporate conglomerates, that is potentially more risky. And another example is Jeff Bezos now owns the Washington Post. Bezos has a lot of business interests that have nothing to do with the media, right? And which are subject to pressure, and that's a concern, no question.
Right. Well, that's a very pessimistic attitude, not even attitude, pessimistic reality, pessimistic view of reality, but an accurate, I think, realistic view of reality. There are a lot of pressure points, and I suppose one thing that could be done is just to have pushback, maybe not even in court pushback, but political pushback. Maybe the fact that ABC has reinstated Kimmel might make the perceived political benefits of doing something like that less for Chairman Carr and future FCC chairman, and maybe the fact that Ted Cruz and other conservatives have spoken out will provide some sort of political pushback. But yeah, this is in many ways, it's not quite an intractable problem. Certainly a problem that's difficult to tract.
I think it's clearly correct. I mean, it's hard to imagine understanding what ABC just did by reinstating Kimmel, except as a reaction to really, I doubt if they recognize just how sharp and bipartisan the public reaction was going to be. Here's another thing, and this is not in my bailiwick because I'm thankfully in no way a proceduralist in courts, but it would be good if we had ways of fast-tracking First Amendment litigation so that delay could not become a tool of just getting your own way, right? Because a lot of this, as I said earlier, it's not that these people, if people who choose to sue would lose on the merits, they would surely win. Many of these issues aren't close on First Amendment grounds. It's that they don't want to bear the delay and expense of litigation. And maybe there's something bipartisan, because honestly, even though right now it's a Republican administration, if I was Ben Shapiro or Tucker Carlson, I would be worried about this turning on me in the future, and I would emphasize equally wrong. And so maybe there is, in the face of this, some stomach, and I say this with all the pessimism due, for some sort of bipartisan sort of movement in Congress to create some procedural ways of speeding up First Amendment.
Attorney's fees. Don't you think attorney's fees would do it?
Attorney's fees are a good start, but I don't think.
Yeah, so there are, if you're talking about procedural tools for expediting claims related to free speech, they actually do exist in many states. Anti-SLAPP laws, even setting aside the attorney fees, part of the point is when you're sued for your speech, you can get it pretty quickly dismissed, the theory goes. Likewise, when it comes to prior restraint is a vague term in First Amendment law, but when it comes to injunctions against speech, courts often appreciate the importance, not always, but often appreciate the importance of dealing with them promptly, and sometimes appellate courts will vacate the trial court decisions in a matter of days, which is blazing fast by the standards of our legal system, surely. But yeah, if you want to have expedited processing as a plaintiff, as a challenger who goes to
as a declaratory judgment sort of case,
that is harder to arrange. And yes, it would certainly help if there was bipartisan legislation. Somehow, I think today this doesn't seem to be in the cards, but who knows? Maybe
no, it's not in the cards today. But
better time.
Maybe this is because this problem is not a problem of today. The Jimmy Kimmel episode brought it to the fore. But it's an ongoing issue that goes across administrations. And, for example, the Biden administration won in the Murthy case on standing grounds. I think that's the correct result. but I sure do not approve of
no.
what they did. No, but to be clear,
Right.
I think legally it's the correct result, but I don't approve.
I don't even think that. But
The problem is not that this is a problem of today. You're right. This is not just a problem of today. The problem is that the legislators are all legislators of today.
Yeah.
They're trying to figure things out as they stand today, and long-term planning, I think, is a hard thing for any legislator who gets up for re-election every 2, or in the case of Senate, every 6 years. But I think these days there's even less attention being paid to the long-term, regrettably. But what can we do?
And I agree with you. I think that, and this particular administration would have no interest in. We're talking about indirect pressure, right?
Right.
We're not talking about prosecutions of speech, because that is easy to litigate. But indirect pressure, this administration obviously has no interest in giving up the levers that it has.
Right.
The only question is, if there's a significant change in Congress after the midterms, maybe there are enough Republicans who see the writing on the wall that they're willing to sort of join in a legislative effort. But I'm getting far out of my depths by trying on this issue.
Indeed. That is to say, indeed, I think all of us are experts on law, but we're not really experts on how law is actually made, and how it is that what it is legislators are going to be willing to do, and what not to do. Because among other things, it's a very sad subject to study.
Yeah, and it's more than just that, though. What has been revealing to me over the past really 2 years, because I include the late Biden administration in this, is how difficult it is to enforce your rights, even when you're clearly right.
Of course.
Right? I mean, even the Vullo case and the National Rifle Association case, they lost in the lower courts, which is astonishing to me, given the facts that they alleged. I have no idea what the truth is, but given the facts that they alleged, the fact that they lost in the Court of Appeals blows my mind, right? But they did. And it illustrates the difficulty of getting, and then they win 9-0 in the Supreme Court, which tells you how difficult it is to exercise First Amendment rights.
Absolutely true. That is absolutely true. And I should say, even in you mentioned, well, at least if you're being criminally prosecuted or sued, you could interpose the First Amendment as a defense. Yeah, there are fewer formal procedural barriers, but still most people will plea bargain. Most people will settle, because there are real risks, there are real costs. If you're paying for your own lawyer, legal fees, all sorts of problems. So yes, the legal system as a tool for enforcing constitutional rights is quite limited in its force.
I think the only people who would welcome a prosecution for something that they've said are First Amendment law professors, whose reputation could only improve with that kind of experience.
Yeah, there you go. So as always, a great pleasure, although I think this one is a particularly great pleasure. Ash, thank you so much for joining us. Jane, great talking with you as well. And Scott Emmergut, our indispensable producer, tells us we have more of these already stacked up in the pipeline. So watch your channels of communication, whichever way you get this podcast. We'll be having lots more interesting stuff coming in the coming weeks.
Great. Thank you for having me.
This podcast is a production of the Hoover Institution, where we generate and promote ideas advancing freedom. For more information about our work, to hear more of our podcasts, or view our video content, please visit hoover.org.